send you a message and see if it was the same link. What is it saying now? That I need to let you in, or?
Yeah, it just says the host has another meeting in progress. So, do you want me to just send you? Should I just send you a Zoom link and do it on my Zoom?
Oh no, there it is. So hello. How's everybody doing out there? I hope everybody is fine and well during all this COVID-19 madness. Conrad L. Powell here today. Just want to talk to you guys about some issues with living trusts, wills, some of the issues that may or may not come up when having or not having them. So I got my colleague here, Dan Weiner. He's an estate planning attorney here in San Diego. We're going to go back and forth with some questions and some answers with regard to some details about living trusts and wills. So without further ado, I got some feedback via email from people here in San Diego with some specific questions, and then I had a couple of questions myself just to kind of put it out there for you guys. So the first question that I had was, so wills versus trust, right? So what is the difference between a will, and how does a living trust prevent probate court?
That's a great question. And before I launch into that, hi comrades, it's great to be here with you, and thank you for the opportunity to share some education with with the people watching. So, and that's a great question to kick off with. So what we often find is that people know that they need to make a will because that's just something that they've always been told. You know, you need to make a will, so people do that. But the trust side is often less understood. So in a nutshell, the will essentially is a device that doesn't take effect until somebody dies. And at that point, it enables you've set out how you want your assets to be distributed. So if you have children, it will say it goes to my children. If not, you've set out somebody else. But the downside of only having a will is that before your wishes can take effect, all of those assets have to go through a court process, the probate process, which here in California can take a long time. It can easily take 18 months for someone to get through that process. And it's expensive, and I'm sure we'll come on to that. But the way, if you want your family not to have to deal with that court process, then you can set up a trust. And the kind of trust that we'd be setting up is known as a revocable living trust. You would, during your lifetime, you would transfer all of your assets into that trust. And in doing that, you're able to set out what your wishes are, just as you can with a will. But after you die, your family doesn't have to get tied up in that court process. Everything would just happen much more easily and privately, and your assets would either be dispersed to your family or held and managed in accordance with whatever terms you've set out in your trust. And the other thing that trusts can do that wills can't do is trusts can operate while you're living. So it's not just when you die, but also if you become incapacitated, if you can't manage your own finances, then you have this trust agreement that allows whoever you've nominated to step in and do that for you.
And that's a good point that you bring up, because as you were saying that, it made me think, like, because I've been in a situation with a real estate client, and their family member was in another state, and they wanted to empower their family to sign off documentation on behalf of them. So like when it comes to a power of attorney within somebody being incapacitated or living, how much authority does that have, and then how far does that go? Does that power of attorney stop once that person passes away, and then the trust becomes enacted as to this is the authority now, or does that power of attorney still stay in place?
So the power of attorney falls away after someone dies, and during someone's lifetime, if we're creating both a trust and a power of attorney, then the power of attorney would only have effect in relation to assets outside of the trust. So the idea is that if we are going to be transferring assets into a trust, then whoever is named as what's known as the successor trustee would be able to very easily step in and manage the assets. Anything that was left out of the trust, you'd be relying on the power of attorney. And it can be much more tricky sometimes to rely on a power of attorney if you're having to walk into a bank and say, I need to take over this person's bank account, they're incapacitated. Banks often scrutinize a power of attorney much more carefully than they do if you walk in as a successor trustee.
Got it. Fair enough. Okay. Well, that was some good information. I definitely I learned a little bit there myself. So we'll roll right into the next question with what are the timelines associated and the cost as well when it comes to someone not having a living trust and having to go through the probate process because they didn't have that created? Timeline and costs.
Sure. So you may have heard this expression, probate-friendly states. Some people refer to those, and California is not one of them. So this state is probate unfriendly, if anything. It is perhaps the worst state in the nation when it comes to probate. So it can easily take 18 months for an estate to go through that court process. And what that means is that during that time, after someone's died, their assets are not available for distribution to their relatives or to whoever's going to inherit, because they're all tied up in this court process. And it's a pretty arduous experience for family members, whether it's going to be your children or whoever's going to have to step in and deal with that. They're going to have to show up at court at inconvenient times. The court is famous for kind of cancelling sessions and hearings at the last minute and making people sit around and wait for hours. And it can be a pretty miserable experience to have to go through. And aside from that, it's expensive. So a good estimate is that 5% would be wiped off of the assets going through probate, and that all goes on attorney's fees and executive fees and filing fees and everything that goes into that court process, all of which can be avoided by creating a trust.
Definitely, definitely. So essentially having that living trust could save a family a substantial amount of the assets or the money that's brought out of the assets because of the cost of paying that attorney's fee. That's good news, good business.
Absolutely. And here, yeah, sorry, just one other point on that. So yes, so imagine, so a colleague of mine had a client and their only asset here in California was a $1 million house. And they had a $600,000 mortgage on it, and that person died. The house went through probate. The value when it comes to probate and houses is the gross value of the house. They don't give you any benefit for having a mortgage on it. So you've got a $1 million property going through probate. The fees on that were $50,000, and that's what was wiped off of the estate. And for a few $1,000s, they could have created a trust during their lifetime that would have saved that entire $50,000 fee.
Yeah, I've experienced some of that myself on my other side of my career with real estate, where I've helped clients who did have trust, and then also dealt with clients who didn't have trust. And it was just being on the real estate side of it and seeing when the final HUD broke down and it showed all the commissions and stuff that was paid out and the amount that went to the attorney that helped the family member, obviously with the probate side, it was pretty substantial. The attorney got more money than the family member did for their fees when the house got sold. So I was just like, wow.
Yeah,
definitely.
Yeah.
So that brings me to the next question when it comes to family members having to take over and deal with it. So if children are placed as beneficiaries to retirement accounts, such as like life insurance policies, 401k policies or annuities, etc., anything like that, how are those assets distributed if there is no living trust?
So one thing that people often try to do is, when it comes to life insurance or retirement accounts, to avoid creating a trust, they will just name individual beneficiaries. And typically, life insurance and retirement does pass outside of probate. So, you name somebody as the beneficiary of life insurance or retirement, they would then inherit, no need for the probate court process. The tricky bit is if you've named a minor. So it's pretty common for people to, if it's a married couple with children, they might have their spouse as the primary beneficiary, and then they've named their 3 children as contingent beneficiaries. Well, then if something happens to both parents, or they're not around to deal with things, if the children are the only ones left, then the life insurance and the retirement is going to go through the probate court process, because minors cannot inherit. So the way to fix that is to set up a trust, and instead of making the minor children the beneficiaries, you would make the trust the beneficiary.
Got it. So with that being said, that brings my mind to think of, what if the children are living with a relative, and because I'm thinking myself, like, okay, well, does that make whoever that adult is that is taking care of the child, does that make them their, obviously guardian, and then the things kind of transfer over to them? Or in this particular case with the insurance policy and the child was the beneficiary, it sounds like no matter what, they're going to have to go through the probate in order to get that money. It's not, or excuse me, or does that?
Yeah, and so we're back into the court process. So it's going to be for the judge to decide who's going to look after a child's inheritance, be responsible for that inheritance until the child turns 18. So it might be the guardian of the child, or it might be someone else who comes forward and convinces the judge that they are the best person for that role. And the person that comes forward and gets appointed by the judge may not be someone that the parents would ever have wanted looking after their children's inheritance. So you're leaving a lot to chance.
Definitely. So it sounds like, if you have children named as beneficiaries to either life insurance policies or retirement accounts, or anything for that matter, yep, you definitely want to have an outline living trust to kind of separate the whole probate process, because they're not going to hand over those assets or the money to a minor child. That's going to have to go through probate.
Yeah, it's usually going to be the answer in a lot of circumstances is to create a trust, so that we can, because it's the trust. Remember also, it's not just about avoiding probate, especially when you're dealing with children, because through the trust you can come up with all kinds of really beneficial ways that the children can receive their inheritance. So instead of them having to receive an inheritance at 18, you can pick later ages, or you can do something more advanced where you create a kind of lifetime trust where the children receive their inheritance in a form of a trust that stays in place for their entire lifetime. And in doing that, you can protect them if they experience anything in their life that could cause their inheritance to be at risk. So if they have creditor issues, or go through a bankruptcy, or get sued, or get married and divorced one day, there are all kinds of ways that you can structure your trust to make sure that their inheritance is protected.
That's interesting. So it sounds like a living trust is a shield, because that individual is not owning or has those assets. The trust owns it. So it's kind of shielded from outside interference or legal situations. Is that what I'm gathering?
So it can be, or it might not be. So it really depends on how that trust is structured. So if you have just a sort of standard revocable trust, and that's all that you have going on, and you transfer your assets in there during your lifetime, that doesn't give you any kind of asset protection, creditor protection, because yeah, it really is as if you're owning the assets yourself. So you don't get any protection for that. But if you go ahead and create other kinds of trusts within your big revocable living trusts, so if you create an irrevocable trust for your children within that trust, then you're giving them asset protection in their lives. So you might not get it for yourself, but it is something that you can give to your children or to anybody else.
The people who are receivers, or what do they call them? I can't think of what they call them.
Yeah, the kind of the ultimate beneficiaries under your trust.
Fair enough. Fair enough. I'm not a I'm a financial advisor, life insurance agent, retirement specialist / realtor. That's why I got you on the line, boss.
That's great, and that's why I don't dabble. I don't give any advice on financial products or life insurance. So we all have our own sphere.
Definitely. Let me see. What's the next question we got here? So, what are some particular issues that can arise in a remarriage or a blended family if no living trust is established, pertaining to like the assets owned by the separated spouses, for example?
Yeah, so this is something that we see it's pretty common that we come across families where it's second marriage, third marriage, and maybe one or both parties have children from a previous marriage. So in that situation, very often creating a revocable living trust is just the beginning of the work that you need to do, because there's always, I say always, there's often a concern on the part of the parents that if something was to happen to them, if they're the first to die, they want to make sure that their children, who are not the children of their current partner, are going to inherit and are going to be okay. So the question then is, how do you create that kind of certainty, that reassurance that the children are going to get taken care of? And again, that involves creating a revocable living trust, but also within that trust, creating an irrevocable trust, so that a portion of the assets will, after the first of them dies, will go into an irrevocable trust, where those assets will be available for the use of the survivor, so the person who survived the other during their lifetime, but there'll be some restrictions imposed around those assets, so that if that survivor then goes and gets remarried one day, or themselves gets sued or experiences some of these life issues, if that happens to them, we're making sure that the assets that are in effect attributable to the one who passed away first, those are going to be protected and not lost in those life events that the survivor's going through. And then after both of them have died, you're making sure that those protected assets go down to where they're supposed to go, which is, the children of the first to die. So there are mechanisms, if you're sort of careful and deliberate in the way that you design the trust, there are mechanisms that you can put in place that give you peace of mind in that situation.
Yeah, that's interesting, because the fact that because to my understanding, when someone is married, the spouses essentially supersede the family. And if there's nothing created, you got two blended families. This family has the wife has 2 kids from another marriage. The husband has 2 kids from another marriage. They get together and now they're married, but their assets aren't protected as to what will specifically go to her kids and what they've created. So the living trust, you're able to kind of create that and protect that, whatever happens from what you just were explaining, you can specify, hey, she came in with $500,000 and 3 properties here, there, and there. Make sure that her kids get X, Y, Z, and vice versa with the other party. And then they can also create something in there that they establish together to where if they have another kid, that kid is protected under there. So is that what a good understanding of what you just explained?
Exactly. It's a great, really flexible device to enable you to really set out exactly what your wishes are and make sure in a legally protected way that those wishes will be carried out.
Excellent. Well, that leads me to the next question, which is this is a good one because I talked to in life insurance, I've talked to a lot of single people as well as couples, and single people I have come across, they'll say, well, why do I need life insurance? I don't need life insurance. I don't have kids. I'm not, who am I going to leave it behind to, blah, blah, blah. So my question is, why would a single person with no kids need a living trust? What happens to their assets if they don't have it? Obviously probate, but why would someone single have to want to protect their assets in a living trust?
So it's really, really similar reasons, I think, to the ones that we talked about. I agree, though, with you that often when you're dealing with single clients, it's, it seems to them less of an imperative to kind of get everything in order in this way. But if you don't want your family to have to go through probate, then you do need to create a living trust. Very often people have nieces or nephews or people who they really, really care about, and they want them to inherit their estate, and they might want to set up some kind of lifetime trust for the nieces or nephews or somebody else, so that when the niece or nephew gets divorced one day, the inheritance they're left is protected. So there's a lot of considerations that are very similar when it comes to single people, and often they are the most complex cases because very often they have a large number of potential people who they want to inherit, and they want a different structure in place for each of those beneficiaries. So, and that's really, to create that kind of plan would usually make sense to do that through a trust.
Definitely. Okay. Yeah, because I get I get asked that question a lot of times, and I think to myself, they're single, they pass away, their bank account, for instance, or their cars that they have, or any of their assets that they have, that could raise a situation where now they got cousins, brothers, nephews, and essentially any of these people can petition the court and bring up an issue or say, hey, I'm showing up at probate, I had a better relationship, I want this and that. And then that brings the judge to have to decipher, okay, well, who's telling the truth? Who gets what, right?
Who is the right person to be handling your own affairs? For each person, that is for us to decide for ourselves. We don't want somebody else making that decision and choosing the wrong person.
Yeah, I was thinking about that before we went on this call, and I was like, we plan for birthday parties, we plan for vacations, we plan to get married, we plan to have kids, but what's the thought to plan how the assets that we create? We don't plan that far ahead to make sure that there's outlined as to how, where, and when, God forbid, which everybody's on the clock here. We don't plan for our assets to be dispersed correctly or how we see fit to our loved ones. So that's definitely a valid point. Let me see. So here's another good one. Can you make an estate the beneficiary of a life insurance policy? And then what are the tax advantages of of placing a life insurance policy in a living trust?
So the answer is yes.
And real quick, Dan, I don't know, your volume kind of went lower. You're not projecting as loud as you were a second ago. I don't know if that's.
Let's see. Can you hear me better now?
I can hear you, but it's not as loud as it was.
Okay. I'm not sure what happened there. There was a plane overhead, so maybe it's better now. I was being drowned out by the plane.
No worries. I can still hear you though.
Okay, good. So on the life insurance, yes, you can make a trust the beneficiary of the life insurance policy, and very often it makes sense to do that. There are circumstances where it does, circumstances where it doesn't. In terms of the tax impact of just doing that, there's very little tax impact of just making a revocable trust the beneficiary of life insurance. But for people who are concerned about potential estate tax issues, so currently the estate tax exemption is at $11.5 million. So you can die with $11.5 million and not have to pay any estate tax. And for a married couple, you can double that. So 23 million, and your estate doesn't have to pay any tax. Those exemption amounts are scheduled to come down. So they're coming down to 5 million in 2026. And
wow.
Word on the street is that given where we are right now with the state of the economy and all of the uncertainty, we could end up sooner than that, in the next couple of years with a much lower exemption amount so that the government can raise money. And by doing that, they will bring many more people into potentially the net of estate tax. So for anyone who does potentially fall within an estate tax bracket, one of the ways that you can reduce your estate for estate tax purposes is to take out life insurance and make an irrevocable trust the owner of the life insurance. So it's known as an ILIT, an irrevocable life insurance trust. And it's often a great way to move some assets out of your estate so that you lower the amount that could potentially be subject to tax.
That's interesting because I've seen where a family had, or it's been brought to my attention, where a situation where the property that they owned was held within the trust as on the deed of the property. So when and then there was a life insurance policy that was in that living trust where it was supposed to pay out to the trustee or whoever was the beneficiary, sole beneficiary, or the next person in line to take over the trust. The house wasn't in there to be paid off, or what the will. I think the will said that the property was supposed to be paid off with the life insurance policy that was in the trust, but the trust didn't outline that. So the trust would supersede the will in that case?
Yes, the trust will supersede the will. And the trustee in that situation would do whatever is the most sensible thing to do. So if paying off the mortgage with the life insurance is sensible, then they will. But if there's nothing that mandates it in the trust, then the trustee has discretion.
They could do what they want.
Something like that. Yeah.
Right. Yeah, and man, it just blew my mind when I experienced this firsthand, and I seen it. Well, I didn't experience it firsthand, but when I seen it, I was just like, wow. And I don't know what the amount of the benefit was in the life insurance policy, but the fact that it was up to their discretion to do how they want, when they want, versus it being outlined in the trust for them to be told. So if it was in that case where it was outlined in the trust, in that case, would the trust pay off the mortgage and then the rest of the proceeds be to the beneficiary, or it's up to that party, the beneficiary of the trust, to do those things according to the trust?
So yeah, so the trustee has to carry out the wishes that are set out and expressed in the trust, and the trustee has to act in the best interest of the beneficiaries. So if there is not a specific instruction, then that's what the trustee needs to keep in mind, because very often it will make sense not to use the life insurance proceeds to pay off the mortgage. There might be kids or whoever's inheriting who want the mortgage kept outstanding. They'll rent out the house, cover the cost of the mortgage, and use the life insurance proceeds to make an investment or buy another house. So there's kind of lots of ways that things can be done depending on the specifics of the family and the asset profile.
Definitely. Okay. Well, let me see. Yeah, this is the last question I got for you, Dan. And this one, and this kind of segues from the one we were just talking about with the fact of the title of a property being held within a estate or a living trust. So it no longer has the two parties who are financing the home or the one party who's financing the home. Title of the property is held in a living trust. What are the benefits of placing real property in a living trust as far as like tax advantages, so forth, or if there are any?
So huge advantages of placing real property in a living trust. Obviously, you're avoiding probates for that house, which is a huge thing in itself. You're going to set out very specifically what your wishes are, what should happen to that house after you die, because that can often, if that's left unsaid, it can often lead to conflict between kids. You know, one kid wants to sell it, the other one doesn't, and there's, you know, you're trying to, the idea is to preempt that kind of conflict and make sure it doesn't happen. In terms of tax benefits of placing it into a trust, there's no kind of specific tax benefit in doing that, because from the IRS's perspective, this kind of trust, a revocable trust, is known as a grantor trust. It's a see-through trust. It doesn't have its own tax identity. It takes the tax identity of the people creating it. So from the IRS's perspective, you own it. So it's you, even though it's in the trust. But from a probate perspective and the ability to control what happens to the assets after you're gone, those are great reasons to put them in the trust.
And that has me thinking about what you said a moment ago with regard to that estate tax that they have that you say may be lowering, what being right now being 11 million. For example, if the owner of a property or a couple owned a home and the house is titled in a trust and they both pass away, that is in their estate. Now their beneficiary of the estate, their kids, they won't have to pay any taxes on the proceeds of the sale of that home if the property is owned by the trust, so to speak, but they're the beneficiary of the trust because of that estate tax, with it being right now, as you stated, 11 million and some change. So is that correct?
Yeah, so either way they're not going to be paying any estate tax if they're below the threshold. So if they die and it goes through probate, there's no estate tax, and if they die and it's in the living trust, there's no estate tax. But within the living trust, there is more that you can do to predict and try to anticipate what may need to happen if there is a change in the estate tax amount. So yeah, that's the real benefit of the trust.
Got it. Well, I think that's all the questions and time that we have here today. I definitely appreciate it. It was some very, very valuable and resourceful information. And that's basically what I'm trying to put myself in a position to provide value and information with, obviously, your expertise. So just in case if anybody is looking to want to, reach out and get some more specific questions with regard to their estate planning, you can contact Dan Weiner. He's located in the UTC La Jolla area. His contact number directly is 949-409-1383. You definitely want to reach out and get some more specific information as far as what costs are, because I'm assuming from my 2 minutes of education about the fees, especially because a lot of people, and maybe you may want to touch on this before we close out, a lot of people will think like, oh, it's expensive and I don't have these assets, or LegalZoom will do it for this amount and such and so forth. So close out. the differences and why LegalZoom as far as a way to go about doing your estate planning versus, you know, working with an attorney like yourself?
Sure. So that's a great question. So when it comes to estate planning, it's not just about documents. It's about, you know, doing a real analysis of your assets. So figuring out, you know, what should be titled in the trust, what should not be titled in the trust, how you go about retitling. A lot of trusts fail because people create the documents, but they never actually get around to transferring assets into your trust. There's some pretty complex analysis these days that needs to happen in relation to retirement accounts in particular. So the law on retirement accounts changed significantly at the beginning of the year in terms of how much tax will your beneficiaries, whether it's your children or whoever, how much tax are they going to have to pay when they inherit your retirement accounts? And that has an impact on, should you make your spouse the primary beneficiary of your retirement, or should it be your living trust, or should it be one of your children's sub-trusts? You know, there's a lot of analysis that needs to happen to make sure your plan works in the way that you want it to, that LegalZoom is not able to do for you. When it comes to blended families, like we talked about before, there's more complexity. And, you know, creating an irrevocable trust within your revocable trust, that's not viable to do through LegalZoom. The other thing that we do that's a little bit different is for families with minor children, we do something called kids protection planning, which involves looking at not just who would be the long-term guardians if something happened to the parents, but also what happens in a short-term emergency situation to try and avoid the circumstances where, you know, the kids are at home with a babysitter and the parents don't make it back, and the police show up and they're not going to know who should be looking after these kids. They're going to have to arrange for CPS to take the kids temporarily while they figure out who the long-term guardians are. So we do planning around that. So really, unless someone is single, very young, no kids, very little in assets, yeah, that person can use LegalZoom probably to get their estate plan done. Everyone else should be working with an estate planning attorney to make sure things are done properly.
Definitely, definitely. And I want to recommend Mr. Dan Weiner for those services. So, you know, do a favor, reach out, you know what I'm saying? I'm pretty sure you can get a consultation and get some information about your specific situation. Once again, his number is 949-409-1383. That's 949-409-1383. And his office is out in UTC, the Hoya area. I want to thank you, Mr. Weiner. I appreciate it. You know, this was great. Look forward to future ones. So thank you very much for your time today, my friend.
Of course. Thank you so much, Conrad, for inviting me. It was a great conversation and I appreciate it.
Great. All right. Till next time, my friend. Take care.
You too.